Okay, hi Glenda. So I've recorded this video for you to have a look at and give me some feedback on. Let me know what you think. So by now you would have received my PowerPoint, which you can follow along with as I talk, or you can just watch this. Yeah, so just send me an email. Let me know what you think, and yeah, great. I'll get back to you. Okay, so the way that we've set it up at the moment is Teresa is going first, so I will follow on from her. Thanks, Teresa, for that introduction. My name's Georgia, and I'll be discussing the topic of wills with you today. Okay, so there are two main questions that I really want to cover in this discussion. And the first one is, should I or anyone else have a will? And if I should have a will, how should I go about it? That's the second question. Slide 3. Okay, topic 1. Should I have a will? Okay, so as you can see, I put the word intestacy up on the board. Does anybody know what that means? Yes? Yes? Yeah, so basically that's right. Intestacy means that a person dies either without a will or leaves a will but does not dispose of the whole property, which means that part of the property, whole or the part of the property, is not effectuated by the will. So what this means is that you can be totally intestate, which means that you die completely without a will, or you can be partially intestate, which means that you have a will but not all of your property is disposed of. Now, when I say property in this instance, I don't just mean the physical house that you live in. I also mean things that you can't necessarily hold, such as bank accounts and shares, and I also mean things that you can hold but are not your house, so jewelry, artwork, and furniture, etc. Okay, next slide. Okay, so there's a misguided assumption that it doesn't matter whether you die without a will because the law will take care of it for you. While this is true, and we do have laws that say how your property will be distributed, a lot of people don't actually understand what the laws actually say and their actual effect on your property and on your family. And intestate laws, which then this is the main issue, that they don't usually reflect your wishes. So, for example, intestacy laws do not include friends in them, so none of your property can go to your friends. It also doesn't allow you to distribute your property how you wish. So, for example, you might not want to give something to one of your children, but intestacy laws say that they get a certain percentage. Next slide. How does a person become intestate? So 45% of Australians die intestate. And not all of them never create a will. Some of them did create a will, but for some reason it's invalid in the eyes of the law, which means that they die intestate. Or some of their property, as I said, is not accounted for. Okay, so the biggest cause of intestacy is that the person never created a will. Pretty simple. Another reason is that a person was married after they created a will. Now, most of you wouldn't know, but if you do get married, the law, your old will is automatically revoked, which means that it's basically like you never made one, you don't have one. Okay, and the third reason is that a person did create a will, but it wasn't valid. Why this might have happened is because it was not created properly. For example, the testator, who is the will maker, didn't sign the will. Another reason could be that the meaning of the words is not clear when going through the will. So, for example, you've included a beneficiary in your will, and a beneficiary in this case is somebody who's going to receive some of your property. So beneficiary in your will is not identified properly. So, for example, you've only used nicknames, you haven't used their name, and you can't distinguish or decide actually who you intended to give your property to. That could be an issue. Another one is the description of your property is not clear. So say that you have, you say, I want to get rid of my property on Jones Street to Penelope. However, you might have two properties on Jones Street. Which one did you mean? Now this can create an issue. And the final thing is that the language used by the will maker was misleading. Okay. And although some of these mistakes, especially to do with validity, can be fixed, it is at a considerable cost because you have to go to court and they have to decide what they thought you meant. And this can cost a lot of time, money, and stress. And traditionally, a lot of these actual, so it's just really not worth you, it's just worth you getting it right the first time. But a lot of these issues weren't a big issue not so long ago because traditionally only lawyers drafted wills. So, but now that a lot more people are creating their own wills using things such as will kits, a lot of these issues are starting to surface. Okay, next slide. So these intestacy laws exist because the law needs to know what to do with your property when you die. But as I said earlier, these intestacy laws don't necessarily take into account your wishes and the people in your life. And this can create problems for the people that you leave behind, and it can cause family disharmony, disagreement, and disappointment. Alright, so if any of these following options to you apply to you, I'd like you to have a think about it, about creating a will, or at least going and creating a new will, regardless of the size of your estate. Okay, so if you have no will, you should definitely consider making a will. Second one, if you have a will, but you have been married or divorced since you created it. So unlike marriage, divorce does not revoke your former wills. What it does do is that it just gets rid of the part where you've left a gift to your former spouse. So that part is revoked. It doesn't exist in the will anymore. And so that part of the will where you've left to your spouse, that property is considered intestate. So, and you might still want to give them something. So if you get divorced, it nullifies that section. So you should change that. All right. The fourth reason is you have a will, but a major life event has occurred since you created it. For example, you've entered into a de facto couple, you've retired, you've had children or grandchildren, or your spouse has died, or any of those things. You should create a will because it changes the nature of your will, and also there are people that need to be accounted for. The one is that it does not include all of your assets. The will does not include all of your assets. For example, since making the will, you've come into a lot of money, or you've bought a property. If you don't account for them in your will, that part will be considered intestate. And finally, you're a bit worried that your will may be unclear. As I said earlier, if it's unclear or your intention is not clear in your will, it may be considered invalid. So it's really important that any of those apply to you. You definitely should be creating a will. Does any of those apply to anyone? Okay. Does anybody know what to do if you need to create a will? Alright, well that's good. Leads on to our section question. If I should have a will, how should I go about it? How should I make my will? Now there are two main ways to make a will, and these are the two most accepted ways in the eyes of the law. So the first one is you engage a lawyer, and this is recommended. This is recommended because they can give you advice on creating a will, and they can also ensure that all of your assets are distributed exactly how you want. The second way you can do it is you can use a will kit. However, this is not advised if you have what we call a complicated estate, and a complicated estate means that, for example, you have multiple shares or multiple properties, or you have a mixed family, or you're in a de facto relationship. It's quite important. It's more complicated. There are more rules, so you should probably engage a lawyer. But it's fine for very, very simple wills. And why I say that is because you must be aware and you must comply with all the requirements of making a will. And if you don't, your will may be considered invalid and you may die intestate. So that can create large issues. And because as I described earlier, your assets will be distributed according to Queensland intestacy laws. Okay. If you do wish to create a will without a lawyer using a will kit, there are a few things that you will need to remember. The first one being that your will must be handwritten or typed. Now, so that means that it's generally not accepted. A will not be accepted if it's scribbled on a piece of paper and does not comply with the requirements set out in the legislation. So as a general rule, we should be using a will kit in the approved form. And it shouldn't be recorded or anything like that. There have been cases where that's been okay, but as a general rule, it should be handwritten or typed. Okay, second point. A will must be signed and dated by the person making the will, and it must be witnessed by two witnesses who see the testator sign, and then they co-sign each other, which means they say, I saw him see the testator, and vice versa. A big thing about witnesses is that a witness should not be a beneficiary. If a witness is a beneficiary, then they cannot take anything from your will. For example, you'd leave your house to Joe, and Joe witnesses your will. Joe cannot get your house. He's revoked. That part of the will is revoked. So beneficiary cannot be a witness, and the witness must be over 18 years of age, and they must be of sound mind. Now, sound mind is just the law's way of saying that they must not be crazy or senile. Okay. The fourth point is, as a general rule, that you should sign at the bottom of each page, and then you should go on to also sign the attestation clause, which is the proper place for signing at the back. And you will see that if you have a will. Okay. The fifth point is that you should not use nicknames. You should use full names and addresses where possible. So by full names, I mean to include middle names. And it's just because you need to be as precise as possible so that your beneficiaries can be identified. There have been cases where 3 people have exactly the same name, and the question is, well, who did the testator mean when they said that they leave their house to Joe Ken Bloggs? Okay. So the next point is that you should describe your property as accurately as you can. For example, if you have more than one car, you shouldn't be saying, I leave 1 car to Penelope and I leave 1 car to Joe. You should be more accurate in your description. The same goes for jewelry, artwork, houses, everything. Be as accurate as possible. If you think that somebody may not like a decision, it's recommended that you write a letter that explains or justifies why you've made a particular decision in this will. And the reason I say that is because if a person feels that they can receive something from your will and they don't, they can, or they don't receive as much as they thought they should, they can bring a case in court and try and argue that they are entitled, or they should be entitled to something or a particular thing in your will. But if you have this letter, the court will look at that and they will, and this is because it explains why you did it, and they will look upon that with a lot of weight. So to avoid any court cases, it's recommended that you write a letter if you think anybody may disagree with the decision that you've made. Okay, and finally, keep your will in a safe place and make sure your executors know where you've put it. Alright, so now I want to go through an example of a very simple will. Alright, so just follow with me on the board. Okay, this is a will dated Wednesday 10 December 2006. It's made by me, Malcolm Smith, of 3 Brown Street, Jonesville, New South Wales. So this is pretty standard. This is how all wills start. It's got the date, it's got is made by me, and then your name, and then your place of residence. Okay, the first section is I revoke all of my former wills and testamentary dispositions. Now this is really important, and this is also included in most wills because it gets rid of your previous wills. Now this is important because otherwise they may go back and look at your other ones and sort of join them together, which is not usually what you want. If you created a new will, you want that one to be followed. But this is a very common clause included in wills, so if you have a will kit, this will be also included in that. Alright, number 3. I appoint my wife, Tammy Marie Smith of 20 Dunstan Street, Greenslopes, as my executor and of my will, but if she is unwilling or unable to act, I appoint my children, Sue Louise Brown of 34 Merry-Go Road, Spring Hill, and John Smith of 2 Jump Street, Redcliffe. So executors are the people that do all the legwork to make sure that your will is executed how you want. So they will close your bank accounts, they usually arrange funeral arrangements, or they'll sell your house if your house needs to be sold. Yeah, so they have a very important job, so it's really important that you ask them if they're willing to take that on. But even if they change their mind, you usually appoint backup executors, just in case something happens or somebody dies. Okay. Alright, clause 3. I give my whole of my estate to Tammy Marie Smith if she survives me by 30 days. Also in the previous clause, you could see that we've included the full names, and we've also included their addresses, just so they can be easily identified. It doesn't matter if they move, it's just a point of reference so we know which Sue Louise Brown you're talking about. Okay, so back to this section, if she survives me by 30 days, so this is just to avoid a double administration, basically, and it's also included in the legislation, so even if that's not in your will, that will apply. Yeah, because you don't want you to die and everything going to Tammy Marie Smith and she dying 15 days later after you've done all this work. Yeah, so that's why they include that. Right, and the final section, if Tammy Marie Smith does not survive me by 30 days, I give my whole of my estate among those Sue Louise Brown and John Smith who survive me by 30 days, and if more than one, in equal shares. So pretty self-explanatory. When it says in equal shares, it just means 50-50. Now this can be different, it just depends how you'd like to give away your property. Okay, and finally down the bottom it says signed by the testator, and testator means the will maker. so the person who's making the will has to sign it in the presence and is attested by witness 1. Witness 1 signs, prints their name and prints their address. Witness 2 does the same, and it says in the presence of the testator and each other. Okay, so if you don't wish to make your own will using things such as will kits, you can. There are people that can help you with that, and the first way is to engage a lawyer. And now while most lawyers are happy to do wills, it might be best, considering, depending on how complicated your estate is, that you see a family lawyer or that you see a lawyer that specialises in estates. Okay, so there are also other services that exist where you don't have to pay to get a will made. Those include family community law centres or clinics, such as the Pine Rivers Community Legal Centre. We create wills all the time. And also the public trustee. So the public trustee has 16 offices across Queensland. And if there's not one near you, you can also go and see Centrelink and the courts and stuff, and they might be able to assist you. But the public trustee is quite good. You can also appoint them as executors, and they will keep your will on file. So if you're interested in the public trustee, the phone number is 1300 360 044, or you can type public trustee Queensland into Google, or you can just search www.pt.qld.gov.au. And I've also put on your tables some cards for the Pine Rivers Community Legal Centre as well. Okay, so if you do decide to arrange an appointment with someone to help you draft your will, there are a couple of things that you need to bring with you. So the first one being that bring as many details of your assets as possible, such as your addresses, very accurate addresses of your property, your bank account details, the details of the shares you hold, descriptions of your jewellery, descriptions of your artwork, including the artist, etc. So include as many details as possible. The second thing is that you should bring the names and addresses of the people who you would like to be your executors. And thirdly, the names of addresses of your beneficiaries. And beneficiaries, as I said before, the people who are going to get something under your will. Okay, so now we come to the final part, and that is a sweet game of true and false. Alright, so if you think something is true, please put your hand up. If you think something is false, please put your hand up. Okay, true or false? If I die, everything will automatically go to my spouse or partner. Okay, so this is false. It's not always the case. If you die without a will, or you are found to be intestate, the Queensland intestacy laws have a very strict formula to distribute your property. This can include children and a spouse. Usually, if you don't have any children and you just have a spouse, then this might be true because it will usually go to them. But there are very strict requirements and rules, so it might not always be the case. Okay, number 2. I don't have any assets, so I don't need to make a will. As I mentioned earlier, the law needs to know what to do when you die. They need to know what to do with your property. So even if you think your estate is not worth a lot, it might be worth just creating a will. And also, your estate might be worth more than you think. For example, a superannuation is included in your estate, so that needs to be distributed. And if you die unexpectedly, for example, you die in an accident, there might be insurance payouts, and this is also included in your estate. So there might be more than you think. Okay, 3. True or false? I can just write my own will using a will kit or a note about what I want to happen. While you can, absolutely, just go ahead and make your own will using a will kit. I recommend cautiousness, but as I said before, it's usually not accepted if you just write a note without following the specific requirements. So that would be a little bit true and a little bit false. Okay, fourth question, true or false? I won't be around, so I don't need to think about it. By taking the time to make a will, and this takes usually no more than an hour, you can save your next of kin so much uncertainty and stress. You will also save a lot on legal cost, because if you don't have a will, it can get really expensive. So as I said before, there are ways that you can create wills for free, and it takes up usually none of your time. And it saves the people that you love a lot of time and energy and money. All right, number 5, true or false? Making a will is expensive. False. There are ways that you can make wills for free. Okay. True or false? I made a will years ago, so I don't need to worry about it anymore. If there has been a major life change, you will need to make a new will. For example, death of a spouse or a partner, death of a beneficiary, death of an executor, you might want to change your will. And you know what? Life changes, and so should your will. It should reflect that. All right, and finally, I move around too much to make a will. Who knows where I'll be? It's not really needed. Or who knows where it will be when it is needed? This is not an excuse for not making a will. There are ways that you can store your will. For example, if you get your will completed by a lawyer, they will usually hold it or hold a copy for you. You can give a copy to your executors to hold for safekeeping. You can, if your will is done by the public trustee, they will hold it for you. You can also ask the public trustee to hold it for you. So this is not an excuse. There are many ways that you can ensure that your will is found when it's needed to be found. Okay, so that's it from me. I hope you enjoyed my presentation. Glenda, let me know what you thought. I'll be contactable by email, and I'll see you when I get back.